Good evening and welcome to the 5th ICG 2020s Development Dialogue. I'm Dr. Pushkar, Director of the International Centre Goa. The 5th ICG 2020s Development Dialogue features Mr. Harish Salve, Queen's Counsel and Senior Advocate, Supreme Court of India. He'll be in conversation with Mr. Dattaraj Salgaocar, Vice President, International Centre Goa. I invite Mr. Yatin Kakodkar, President, International Centre Goa, to make the introduction. Thank you.
Good evening and a warm welcome to the International Centre Goa and to the 5th webinar program of the series 2020s Development Dialogue. The topic today is the Constitution of India and the rule of law. The Constitution is a pillar of India's democracy. It divides power between the executive, legislature, and judiciary, thereby creating checks and balances. It establishes the federal nature of our political system by dividing power between the union and the states. It specifies the scope and boundaries of legislative power and the sharing of tax revenues between the union and the states. At an individual level, the Constitution enumerates fundamental rights relating to equality before law, right to life, personal liberties such as right to speech and expression, religious freedom, etc. The Constitution also addresses socio-economic issues in the directive principles of state policy, which it says are fundamental in the governance of the country. Indeed, the Constitution of India is the most important document in our democracy. To shed light on the Constitution of India and the rule of law, we are privileged to have with us Mr. Harish Salve. Mr. Salve was formerly Solicitor General of India during the period 1999 and 2002, and is a senior advocate at the Indian Bar, practicing largely in the Supreme Court of India. He famously fought the case of Kulbhushan Jadhav at the International Court of Justice. In January 2020, he was appointed as a Queen's Counsel for the courts of England and Wales. Mr. Salve began his legal career in 1980 at J.B. Dada Chanji and Company, first as an intern and later as a full-time lawyer. During this time, he assisted Nani Palkiwala in the Minerva Mills case. He was later designated as senior counsel by the Delhi High Court. Some of his notable involvements include the Vodafone tax dispute, first anti-dumping case in the Supreme Court of India, and the Arushi Hemraj double murder case. In 2017, India Today ranked him 43rd in a list of India's 50 most powerful people. Mr. Salve was awarded the Padma Bhushan in 2015. In conversation with Mr. Salve is Mr. Dattaraj Salgaocar. Mr. Salgaocar is the chairman of the Goa-based VM Salgaocar Corporation Private Limited, with a presence in hospitality, real estate, and private equity. He is passionate about education and the arts, and his foundation runs schools and colleges in Goa. He founded the Sunapran Goa Center for the Arts in 2007, which has transformed the Goan cultural landscape. He's a production engineer from VJTI Bombay University and an MBA from Wharton Business School. Mr. Salgaocar is a founder member of ICG, vice president of ICG, and chairs the ICG Programs Committee. Before we start, ICG is pleased to announce that the speaker for the next webinar in the second half of May is Dr. Ritu Karidal, Deputy Operations Director of India's Mars Orbiter Mission, Mangalyaan, from Indian Space Research Organization. I now hand over the session to Mr. Salgaocar, and I hope you find it interesting. Thank you.
Thank you, Yatin, and it's my privilege and honor to welcome my good friend, Mr. Harish Salve, to our dialogue. Thank you so much, Harish, for being here with us on a weekend especially, and thank you for the grace of your time. I shall dive straight in, Harish. How did you embark on a career in law despite having studied and practiced chartered accountancy in Nagpur? In an interview many years ago, you hinted it might have been by reading Perry Mason. Growing up in Nagpur, who and what were your earliest influences in terms of how did you understand the world around you, your values and your beliefs?
Thank you, Raj. The entry into law was of course, when I was in class 8th, I wanted to be a lawyer because I used to read Perry Mason. Career choice had changed in a few years. I wanted to be an electronics engineer because I could successfully destroy any bit of electronics with a screwdriver. But it sort of changed again when I went into college. And when I passed my HS, my father made a offer which I could not resist. He said, I'll pay you 50 rupees a month if you start doing your articles. And, you know, in 1972, 50 rupees a month was a princely sum. So I started working in Salve and Company and started doing my articles. And early into chartered accountancy, I realized that I should have had a plan A and a plan B. Plan B should have been chartered accountancy. Plan A should have been everything else. But it became an ego problem because everybody said, oh, you're Mr. NKP Salve's son, you will never pass CA. So I said, okay, I will pass it and leave it. That's how I finished my accountancy. But I remember 1974, 75, Mr. Palkewala was going around giving speeches on why, criticizing the proposed 42nd Amendment, one of the frauds perpetrated on India in emergency time. And we, of course, heard his speech. And as he was leaving, a friend's father who knew him, we were escorting him out, and he looked at me and said, he knew my father very well. So he said, Harish, how are you? And I said, very well. He says, when are you joining the bar? I said, very soon, sir. The die was cast. So that's how I became a lawyer. And, you know, Nagpur has a large legal fraternity. When Nagpur was the capital of CP and Berar, before it became a part of Maharashtra, Nagpur had its own high court, which now is a part of the Nagpur bench of the Bombay High Court. And Nagpur has a large retinue of lawyers. They all live in one area in Nagpur. And a lot of their sons were friends, including Nagpur's ace lawyer that time was Mr. A.S. Bobde, popularly known as Bhau Bobde. And his son and I went through school and college together. His son is also a well-known lawyer, whom I'm talking about. So that's how it was. There was a lot of law in the air, as they say. And that's how my ambition for law was even further fueled. So that's how we drifted in. And it was good fun. It was before the era of social media. It was before the era of Nagpur having clubs and Nagpur having bars, where entertainment was getting into a jeep and going into the forest. And partying meant going to the border and sitting on a charpai and having a glass of beer and eating with the truck drivers. So that's how we grew up. And it was a very different life, and it was good fun. So it was a life where your anxious moments you spend arguing with friends about completely irrelevant things. So your knowledge also grows. And we all read the printed word. There was no computer, there was no screen. So it was a wonderful life, very easy. Early morning in Nagpur terms means 11 o'clock in the morning. So it was a very laid back life and enjoyed it thoroughly. I miss it sometimes. You're on mute, I think.
Thank you so much, Harish, for sharing your childhood with us. You're undoubtedly one of the most, the best, I would say, constitutional lawyer in the country. We would like some sort of thing on the Constitution. Which Bill of Rights inspired the Constitution of Free India? And what was the role of Dr. Ambedkar in writing our Constitution?
So it's, I'm going to say something controversial. What use is it spending a Saturday morning if you don't say something controversial? Actually, very few people outside the legal world know our Constitution is to a substantial extent in its working provisions, a reproduction of the Government of India Act 1935, which the British Parliament had passed, including the British Parliament had started with devolution. And the jury is still out whether we should have first been maybe a dominion which would have then matured into a full-blown democracy, or whether we started well. But the Government of India Act was the basis on which we started writing up our constitution. And of course, we had the model of the American Constitution, which had a separate Bill of Rights, which came in through the amendments. And Ambedkar was the driving force, but there was a person who Ambedkar relied on very strongly. Dr. Ambedkar used to rely on a gentleman called Mr. B.N. Rao, R-A-U, that's how he spelled his name. He was a great student of constitutional law, and he met constitutional lawyers in Europe, he met constitutional lawyers in America, including the famous conversation he had with, I think, Frankfurter, who told him, do not take in the due process clause. It's an unruly horse. That's when we rewrote Article 21. Of course, our Supreme Court has now brought it back to due process by construction. And those are the people who guided him in writing up our Constitution. And we also had a lot of inputs from people. We looked at, for example, the Irish Constitution, from where we picked up the directive principles of state policy. Minority rights was almost entirely our own creation. We had the American model, which we looked at, which is what is called the complete wall of China between the state and the church. And then you had the other models where there wasn't such a strong divide. We brought it in. Unfortunately, our Supreme Court read it down slightly, but we also brought it in Article 25 too. So we had a lot of influences, but the primary influences for Bill of Rights came from the American Constitution to an extent, where we departed in certain areas and where we didn't bring in certain areas, and the Government of India Act and other constitutions which had worked. But one very important thing which we picked up, and that's very significant, the American Supreme Court invented judicial review. There is no provision in the Constitution which says the US Supreme Court can strike down a law. They created it saying, if this is what it is, then as a judiciary, we must have the power to say that some law doesn't accord with the federal constitution. We didn't want to leave it to chance, so we added an express provision for judicial review, including we added Article 32, that to enforce fundamental rights, we could directly move the Supreme Court. So wherever there were evolutions in the law, we picked them up and made express provisions. And that is why we have a very elaborately written constitution. And we've had changes made to our constitution from time to time. We have had tinkering with Part 3 of the Constitution. And maybe it's a debate for some other day whether any of those were really necessary, other than changes like GST or others, which have, of course, brought a new economic principle in. But it was one of the most wonderful documents which have ever been written up.
Thank you, Harish. Can you tell us, I mean, there have been various amendments to India's constitution. I mean, over the last so many years, some politically inspired, some based on other things, and many were overturned. What, according to you, are the three key amendments and their relevance and importance to us?
The three key amendments which have been made. One, ameliorative, and two, destructive. The first amendment was made by Pandit Nehru, who displayed his impatience with the judges when he brought in the 9th schedule, the first amendment, he brought in the 9th schedule, where not only did he put agrarian laws beyond Part 3 of the Constitution, but he brought in a list which, by its plain text, meant that any law put in that list would be immune from a constitutional challenge. So virtually what that meant was, if 2/3 Parliament present and voting passed a law and said this should go into the 9th schedule, Part 3 and fundamental rights would not apply. This was challenged for the first time, and Subbarao innovatively found a way of striking it down. That was in Golaknath. But Golaknath was reversed. The main challenge in Keshwanand Bharati was to these provisions, and they upheld it. Although they brought in basic structure, and it should be it's to the credit of the Supreme Court. I think in 2006 or 2008, Justice Sabharwal constituted a bench which heard what is known as the Coelho case, which came from Goa, I think. And that is where they have read down the 9th schedule to mean even a law put in can be tested now on the basic structure. And the basic structure means Article 14, 19, and 21. So they have sort of tried to neutralize it. And I appeared in that case. I call it the dirty laundry list. All your laws which you feel violate Part 3 are put in that list. And Mr. Palkhiwala described that amendment. And then came the 42nd Amendment, by which Mrs. Gandhi institutionalized that by saying, actually, any law in favor of any directive principle will not be challenged as violating Part 3, which is what Supreme Court struck down in Minerva Mills. That was the second destructive amendment. And I still remember from his speech, Mr. Palkhiwala said the only justification for this amendment, because what Mrs. Gandhi said is, it's the fundamental rights which stands in the way of India's growth. And Mr. Palkhiwala said, this is a bad workman who quarrels with his tools. And the third ameliorative amendment was where we outlawed emergencies. So now internal emergency cannot be imposed anymore, like the phony emergency of 1975.
And in your opinion, are these landmark judgments still most valid today? I mean, you mentioned Minerva, or would you say there are other landmark judgments which are even more important?
The foundation of present jurisprudence is in basic structure, which is the Keshwanand Bharati case of 1973, after which the angry daughter of an angry father, Indira Gandhi, superseded 3 of the senior-most judges who had participated in that judgment. Later on, in 75, she superseded Justice Khanna. So they were very clear they didn't want any judges who would stand up to them. So that was the first judgment, which even today is referred to as the starting point of a debate on constitutional law, the basic structure theory. Minerva Mills took it to the next level, where we developed what is called the trilogy of rights, the golden triangle, Article 14, 19, and 21, which was followed by Maneka Gandhi, in which we did a U-turn on due process, where we brought in due process. So we said, if you are deprived of your liberty, and liberty was given a very wide meaning, not just physical liberty. The right to travel was considered, for example, a part of liberty. And we held that you can be deprived of liberty only by authority of law, but that law must be just, fair, and reasonable. So which is nothing else but due process through the back door. So we brought in that not just any law, but a law which is just, fair, and reasonable. That's been the second major development of the law. And these have provided the basis for the Supreme Court taking the law forward and creating a wonderful jurisprudence of human rights in India, which we are justifiably proud of.
What would you say are your three most challenging cases and also your most satisfying cases at the same time? Satisfying from your own personal point of view of, helping the country, building the pillars, the constitution, the strength of the country, not just remunerative, I would say, but just from helping our country become stronger. What would be the three of your own?
Actually, the cases which are most satisfying have been the cases which have been without remuneration. It just so happens. Personally, I was one of the biggest challenges was arguing the bearer bonds case in 1981. Where I was all of 2 years at the bar. And I used to be in Soli's chamber, and we challenged the bearer bonds law. Soli went away to Jammu High Court to argue the first challenge to the anti-defection law in Jammu, to defend the anti-defection law in Jammu and Kashmir. Didn't come back in time, so I was asked to argue before 5 judges of the Supreme Court. And I must say, there was such a wonderful bench presided over by Justice Chandrachud, Justice Bhagwati, we had then Justice A.N. Sen, we had Justice A.C. Gupta and Fadl Ali, and we're forgetting fifth judge. So it was a wonderful bench, very, very encouraging. And of course, when it came for my rejoinder, I was so tense, I developed a fever. But that sort of took the, it takes the fear of flying out of you. So never look back. But that was very satisfying. The other satisfying cases which I did, which I feel have helped a lot, were the environment cases, the forest and the wildlife cases which we have done, the clean air cases which I've done, all as a amicus curiae. And I think we've created a consciousness in the country and in the courts, which has been a huge help. So that has been that work has been, it was very taxing, but it was very, very satisfying. One of the cases I argued was, it's not very well known, challenge to the narco analysis case. And I argued that pro bono, and we succeeded, saying you cannot forcibly have narco analysis. So, it's sometimes these cases which, as a constitutional lawyer, you thoroughly enjoy, even if you're not paid a fee. And those are the cases which I think have helped develop the jurisprudence. I argued Coelho. Coelho was where we argued that the dirty laundry list, the 9th schedule, has to be made subject to the basic structure principle and therefore subject to the trilogy of rights, and we succeeded. And that was another free brief. It wasn't a paid brief. So these have been the most enjoyable cases.
I think this is great inspiration for all our young lawyers. Thank you, Harish. Moving on to Sabarimala, that is the Supreme Court in Sabarimala entry case said that constitutional morality should prevail over social morality. Would you agree with this? Because there are concerns in invoking constitutional morality by the court, because what is constitutional morality may depend on the sitting judge at that court believes and may be limiting. What do you have to say to that?
See, would it make any sense to you if I was to say goodness must prevail over generosity? It makes no sense. Constitutional morality is one of the most important dimensions of social morality. So I frankly didn't understand that formulation. We have a constitutional principle of freedom of religion. We have a constitutional principle of gender justice. It's a very delicate balance between the two. Preserving the right to one's religion is recognizing a part of a very basic right of freedom of soul, freedom of consciousness, without which you cannot have a democracy. What worried me about the Sabarimala judgment, while nobody questions the need for gender justice to be brought into our religious practices, what concerns me is law going to be the medium for repairing religious malpractices in religious areas? Now, for example, in Sabarimala, they say, I don't profess any knowledge of Hinduism, but what the argument is that it is integral part of the faith around that temple, which causes this, what the gender justice people call misogyny, that women are not allowed inside. This reform, should it come from the Hindu community or should it be brought by law? And that worries me. And it worries me for the reason that you then have to resort to nebulous concepts such as constitutional morality as distinct from social morality. What would you feel tomorrow if the government of the day felt certain practices of the church are equally incompatible with a sense of justice, or certain practices of a synagogue or certain practices within the mosque are incompatible? You have the gender discrimination in a mosque where there are areas where ladies are not allowed to enter. We have so many, in certain parts of Hindus, females do not join funeral rites. There is a section of society which says all these must be reformed because this doesn't make sense in the 21st century. There is no question about the need for reform. The point is, if you allow the legal system to bring in reform to elements of religion, it opens up concerns of where this right, which is one of the most sacrosanct rights, the right of freedom of expression through a religion, is to an extent diluted. So while I completely see the force of logic of saying women should be allowed to enter the temple, resorting to things like constitutional morality and social justice, and trying to suggest that there is an apparent tension between the two, and therefore one of the two must prevail, this worries me, because this is too amorphous a basis on which such a precious treasured right is going to be, in one sense, acted upon. So while the conclusion of the judgment may be correct, it's under review, it's to be argued. I don't know enough of Hindu law and Hindu religion to be able to off the cuff say whether the judgment is right or wrong. But it's a matter of grave concern, and that is why it needs to be very carefully considered.
Thank you, Harish. Let me move on to rule of law a bit. As India becomes a global power, there's a need to have stronger institutions and a firm rule of law and its enforcement. The rule of law seems vital to enable a well-functioning society. And following those laws mandatory whether we agree with them or not. Please explain to us the importance of rule of law in our society.
See, when we start with the rule of law, we say it's the rule of law versus rule of men. That's the meaning of rule of law. Rule of law means however high you are, the law is above you. The rule of law means your rights are recognized, delineated, and guaranteed. And rule of law means there is a robust, independent judiciary who protects your rights. All this we have, but rule of law has certain other elements too. Rule of law means you must have an honest executive. And when I say executive, I mean both the political executive and the civil service. We had almost reached a point in India where the phrase honest executive started sounding like an oxymoron. I think we have turned away from that, at least to some extent. And yet when we feel we have moved away and we have moved up, something like what is happening in Bombay happens, which shakes the foundations of rule of law. We have another element of rule of law is the enforcement of law. And if the Commissioner of Bombay, which is India's prime financial capital, the Commissioner of Bombay Police is of the kind who we have just seen, and the Home Minister of one of India's prime states is of the kind we have just seen, God be with the rule of law. Rule of law also means a very insulated and sensitized criminal law jurisprudence. And I personally feel this trend, which started with Supreme Court hearing the telecom licensing case, where industrialist bashing became the fashion of the day. It suited the politicians to get the heat of themselves and turn it on to the business community, which has led to a very strange development in the law of bail, where today our whole justice system, criminal justice system, has become a system of trial by embarrassment. You're arrested where you need not be arrested, because there is an allegation, and especially in big cases, the allegation hits the small TV screen with people screaming about when will justice be done. So you have the lynch mob, you have the bloodletting crowds already to go, followed by arrest, followed by embarrassing leaks from the police, followed by incarceration, followed by refusal of bail. And we have zero accountability. In the UK, where they do not have a written constitution, the courts here have recognized that you can sue the police for false arrest. Believe me, if there was rule of law, the judges who in the telecom case oversaw the investigation and all the police officers who conducted that investigation and put people in jail, which has led to 100% acquittals, all of them should be made accountable. So this is where, if India is to really grow, you know, today when people come to me in London to consult saying we are investing in India, I look at them and smile and say, you're very brave people. I know of a case where some Samsung dealer somewhere in Bihar made a complaint because his little franchise for running a Samsung store was terminated. He put the chairman of Samsung saying he has conspired with the local Indian staff to terminate my shop. And the criminal court issued a summons. The High Court quashed. The Supreme Court reversed and said, of course, he must come and answer. Now, if this is how you're going to administer the rule of law, it becomes just a weapon of oppression. So this is where we really need to fix our rule of law. Our criminal justice system has to be depoliticized. I mean, look at the treatment Arnab Goswami got. You may like his channel, you may not like his channel. See the treatment he got. They arrested him, they threw him in Taloja jail, and read Justice Chandrachud's judgment from the Supreme Court, saying if tomorrow you do not pay somebody because you have a dispute with him, you pay him part, you don't pay him part, and he has other creditors and the creditors are beating his door down and that person for some reason commits suicide, you have to be arrested. If that's the law, then how many of us are safe? And arrested and denied bail and put inside a jail. You read if Justice Chandrachud's judgment is worth reading. He says, how can you even call this an offense? So, you know, this is where, and is there any doubt as to why he was arrested? There was no doubt. Now, if in 2021, the criminal justice system can be used like this, which businessman will be safe? And why would anybody want to really invest in India and open himself up to this kind of treatment? So this is where we need serious repair if we need to bring back rule of law. And finally, I must say, I don't want to talk too much about this, but the Vodafone, the Supreme Court decided in their favor. You brought a retrospective law. The finance minister said, we will let the international tribunal decide. You embarrassed yourself before an international tribunal, which gave certain very stern findings against India. You're not accepting that. You're challenging it in Singapore. Now you, the Republic of India, are asserting sovereignty by giving up your right to immunity and surrendering yourself to the jurisdiction of the Singapore court. If the Singapore court says something nasty about you, have you done yourself proud for how much? $2 billion, $3 billion of tax? And what is the message you're giving to the business community? So, you know, these are certain things which have come, which have dented India's commitment in public perception, India's commitment to the rule of law, which needs to be fixed.
Thank you for your candid views for this. You know, in fact, you have also referred in some of the TV interviews, Harish, about the difference between our rights as citizens and our duties as citizens, that rights are not absolute as some come to believe. Could you also elaborate on this?
See, we have rights and we have duties. Democracy is work in progress. And as everybody says, freedom survives as long as you have the twinkle in the eye of the common man. Freedom is the most fragile virtue. And according to me, the biggest threat to freedom comes from freedom. You have the right to criticize. You have the right to call the government. You have a right to express views which differ from the views of mainstream. But is there a boundary? Is there a boundary which says you will not question the territorial integrity of India? Or is it your right to say that the Indian army in Kashmir is an occupying army? Is that freedom of speech? Is it your right to say that we must not allow the Indian flag to fly on the Red Fort and we must wave the flag of a terrorist organization. Is that your right? Does freedom of speech extend to inviting people to anarchy and physical violence? If you have a right to protest, the average citizen of a city also has a right to go about his business. I do not agree that your right to protest includes the right to make life a living hell for others who are going about to earn their daily bread. So your duty as a citizen is to respect the rights of the others. You see, as they say, my right to stretch my arm ends at the tip of your nose. And that it is my duty to stop my arm from stretching the moment it reaches the tip of your nose. And this is the confluence of rights and duties of citizens. We must have certain things on which we agree. Do we agree to the idea of India, or you don't agree with the idea of India? If you agree to the idea of India, you may say this is not the way to govern India. You may disagree with certain measures taken by India. But certain offices have to be respected. It is your right to criticize judgments. It's your right to criticize the judiciary. But today what we see, I'm sorry to say this, today what we see is binaryism. A group of people are so intellectually convinced of their own infallibility that if they support a cause and that ends up in court, the judges can do one of the two things: either decide in their favor or be considered supine and spineless or dishonest. This binaryism, that either the judge is honest because he decides in my favor, a judge who doesn't decide in my favor is dishonest, either intellectually or pecuniarily or in all ways. Is that a right? And is that a part of freedom of speech? Or is it your duty to protect the institutions with whom you disagree? It's very easy to champion the cause of those with whom we agree. But with that, don't you have a corresponding duty to tolerate dissent? So this is the right and duty interplay, which I always consider has to be kept in mind.
Thank you, Harish. Let me now move on to something which is happening all around us, especially during the COVID period, because of we are all bound to home, online, Zoom calls as we are doing now. So technology is having an enormous and far-reaching impact on the lives of both ordinary people and the nation state. I mean, the law, when you studied it in the 70s, may not have all the cyber laws and whatever which are there now. There is a great deal of controversy over the role of Twitter and Facebook and other social media platforms, and their desire to monetize personal data, biases, intrusion on privacy, and such matters. And I don't know whether laws have been able to keep pace with this environment, and whether they have become so large that they are not able to rein in their monopolistic tendencies, as was done in the past in the US for Standard Oil, AT&T, and all. I mean, Facebook, Alphabet, Apple, and Twitter, they've become so large, and every time they are termed as monopolies or very, very competitive and aggressive, they just somehow get away with whatever they're doing. Do you think such corporates will be brought under control? Will there be laws for them to make them manageable? And to end it, of course, what about India?
You're absolutely right. The cyber explosion and the development of social media has presented the kind of challenges which lawyers of my generation, frankly, are perhaps even ill-equipped to deal with. We are all struggling, and it raises certain very far-reaching questions. Today, Twitter, Facebook, and other similar platforms have arrogated to themselves the right to censor what goes up. In America, censorship is considered per se unconstitutional because it is considered pre-speech restrictions. In India, we have recognized censorship of newspapers to a very narrow extent. Censorship was always considered what the government did. Nobody ever contemplated there would be a private player who would become such a public utility of such a magnitude that today I think the social media has become the primary carrier of news as compared to it's social media, then I think it's the electronic media, and then it is the other forms. And the social media has made every person with a point of view a publisher. So where do we draw the balance? The jury is still out on should companies like Facebook and WhatsApp be compelled to have a takedown policy in which they now become responsible for making sure objectionable content is removed? Or the other counterpoint is, how can you allow a private profit-driven agency to invade my right of free speech and shut me down? Now, this issue of principle has not yet been resolved. A very interesting case is going to come up very shortly. I can lead you on to it. The latest rules which have been published, for example, for tracing. Now let's take this, the toolkit which was put up. Now the police wants to know who was the first person who put it up. So they asked WhatsApp, can you tell us who's the originator of the message? So now they've amended the rules and said, you must give us the first originator. Now WhatsApp is end-to-end encrypted. WhatsApp doesn't know who puts up which message where, and they don't store messages, they delete messages. If they compel WhatsApp to start reading messages, because the only way a company like WhatsApp can get to the original message and tell you, this is where it started, that means you're telling him to read the message. So it's like telling the postman, you must read every letter you deliver. So that if I ask you, you will tell me who was the first one to write that. Then what happens to my right to privacy? If they read every message, then my messages to my daughter would be read. Your messages to your daughter would be read, as much as a message to your wife, to your girlfriend, to your mother, to your father. Everything will have to be read to keep a record of that message. And then how do you prevent them from monetizing it? The information they derive from it. So these are such issues. But then on the other hand, the government says, if there's child pornography, if there are pedophiles, if there are terrorists who are using these, should we not have a right to get to them? Now, these are such important principles which have come into conflict. Writing the law is going to be the next step. I don't think we have as yet resolved which way to go, because you have on the one hand the Supreme Court upholding the right to privacy, and they struck down the private recourse to the Aadhaar card. The law has been amended. I'm sure that will be challenged. And on the other hand, you have telecom operators who say, I can give you the phone free if you give me your data. And a lot of people won't mind that. So these are such issues of principle. I think as a society, we have to come to certain conclusions of how far we want to take which principle. And then the laws will follow.
Okay, it'll take a while, I guess, and we'll wait to see how this thing unfolds. Let me ask you about your experience. You charge ₹1 for this famous Kulbhushan Jadhav case in the International Court of Justice. And you've done us proud, Harish. I mean, we are all so proud of you. And the way you argued, and the Pakistani advocate there also was quite a piece of work. Could you share us your experience representing India at the princely sum of ₹1 at the International Court of Justice?
Well, I must start by telling you I have done so much work for the government of India, including appearing for CBI, for example, back in the day in the Upahar film fire case. And I made it a rule whenever I appear for the government, I charge ₹1 because it avoids unnecessary controversy of how much fees is being paid. I burnt myself very hard initially, even before I'd ever appeared for government of India, because my father once called me in '93 when he was Minister of Steel Mines and said, "How many cases have you done for Steel Authority? I want details immediately." So I reached back and I found out. And I said, in the last 6 years, I've done 3 cases, total fees received was ₹6,000. Because somebody had gone and complained to the Prime Minister that Mr. Salve, from the time he has become Minister of Steel and Mines, has been passing on works of all the PSUs to his son. So my father told me, "Promise me till I'm a minister, you will not accept any paid brief from any PSU." So from that date, I started appearing free whenever I learned my lesson. When it come to Kulbhushan Yadav, the case started very interestingly. In a TV debate, I must have said this should be taken to ICJ. It got picked up in the PMO. Somebody told Sushma ji that Mr. Salve is saying this, call him. So I was called and said, deliver now, you open your mouth, do something about it. So we researched the law, we found some way of taking it to the ICJ. The thing is, it had to be kept so confidential that it was dictated by me and one junior from my chambers on my desktop. And I used to disconnect my desktop from the internet when I used to work on this. Saved on pen drives. That pen drive used to go to the secretary in the ministry who'd make changes. And this is how we worked it. There was only one printed copy, which was printed in Sushma ji's house, which she read, made some changes. We took down the changes. She said, leave this copy for 1 day. She went and showed it to the Prime Minister, brought it back. That copy was destroyed and it was back on a pen drive. And the briefs were printed in Blackstone chambers, not even in India. So this is how we have to keep it secret. Then somebody said, what fees will you charge? I said, I never charge a fee. They said, no, we need law ministry's permission for your fees. And the moment they would have applied to the law ministry, the whole world would have known that India is going to the ICJ. I said, forget about the fees, ₹1. I said, for that, you don't need any permission. And it's a beautiful postscript. I spoke to Sushma ji at 8:45 at night. I was in Delhi and she told me, when are you going to come and collect your fee? And I said, I'll come tomorrow and meet you. I put the phone down. 1 hour later, she was no more. And her daughter then presented me. She got a silver coin with ₹1 made for me. And she gifted me that.
Let me ask you about public interest litigation, which has been hailed by many or some as the most dramatic democratizing move that the Indian judiciary has made post-independence India. On the other hand, according to a legal scholar, PIL was a tragedy to begin with, and over time it has become a dangerous farce. What is your take on PILs?
My take on PIL is, if you look at it, if you step back and look at PIL as an institution, it is not PIL, but it is the court itself. And what the court has done is it has redefined itself. The Supreme Court of India is no longer just a dispute resolution tribunal. It is an institution of governance. And that has hugely helped strengthen democracy in India. At times when, especially between 1991 onwards, and in between 2004 and 2014, when at times you felt there was no government. I mean, I remember my own comment on TV. Somebody said the Supreme Court is running India. I said, well, as citizen Salve, I said, thank God somebody is. So to some extent, the judiciary, by becoming an institution of governance, has demonstrated to the Indian people that there is yet another institution which can take up complicated cases and deal with them objectively and transparently. So I think that has hugely strengthened Indian democracy. Now, any such evolution is, I used this earlier in the day, Lord Sumption used a very nice expression in a speech about development of law in these areas. He says it is always crab-like. It's one step forward, one step to the left, one step to the right, half a step to the back, and then yet another step forward. It's never it never moves in a linear pattern. It's always, and that's because you feel your way through. So there have been judgments which have been way over the top. But if you stand back and look at it, today, do you not as a citizen feel confident that if something goes horribly wrong, like what we saw in Bombay going horribly wrong? And is there any doubt in an Indian's mind that this had to be investigated by an outside agency? It could not be the police itself, which was in the cauldron. And the court stepped in and ordered that. Now, at least as a citizen, we feel, well, if a thing like this reaches the court, it comes into public domain. It is dealt with transparently in an open room. And there is some hope that it will be resolved with principles consistent with the rule of law. So I think this has been a very positive move. Yes, it has had its aberrations. And it has found the court has an identity today. And that identity is very important for the court and for Indian democracy. You're on mute.
Coming to Goa now, just to change track because we're running out of time now. We always like to end with Goa. Recently Justice Bobde was in Goa and he hailed our uniform civil code and he said this is what the framers of our constitution envisaged for India. He said, quote, "I've had the privilege of administering justice under that code. It applies in marriage and succession, governing all Goans, irrespective of religious affiliation," unquote. What are your views on uniform civil code, and do you see it being implemented in the rest of India?
You know, the Goan code, and we've always, I don't know too much about it, but I have some idea of how it has worked. And I think it's worked beautifully in Goa. And I think, I don't mean to be patronizing, I hope I don't come across that way, but I think Goa could be a great model for India of how diversity can be preserved and how diversity can blossom. Goa has evolved, but Goa is still Goa. It hasn't lost its identity. I've been in Delhi from 1976 till 2014 when I almost shifted out. In the last 4 or 5 years, I've hardly been in Delhi. I think Delhi is a city which has lost its identity. If we can go back into celebrating our diversities and have, for our purposes, codes which conform to our diversity of our region, rather than have a slam dunk law across India. It could be something which we could do. And I think today, to some extent, the intolerance you see in society is coming because we have lost celebrating diversity. If the rest of India could develop the same temper as Goa, I think India would be a much better place.
You're always kind to Goa. Thank you so much, Harish. I have a couple of questions from the audience. So would you like to just take one of them? And one question is, what are your comments from Raghav Khanna? So we would like to hear your comments on reservations in India.
I have always been a critic of reservations in India. And my one-liner argument is, our constitution was put in place in 1950. We are in 2021. 61 years down the road. If reservations have worked, they should have achieved their purpose and they should be removed. And if in 60 years they haven't worked, they are obviously a failure and should be removed. So I don't think you see, reservations made sense when government jobs gave you status. In the British days, people used to hanker for a company job because that took you out of your caste system. It gave you access to the British justice system, which gave you more access to the system, which gave you fair justice, which you would be denied if you belong to a lower class. So it gave you an identity. It gave you status. A job was not for money, a job gave you status. A sarkari naukri was your way to escape from your caste. Today, this has become an economic measure, and it's become a completely politicized measure. So I personally feel that the principle of reservation, which I have always considered, is a digression from the principle of equality, should be revisited in an objective debate. Whether the time for that debate is right or not is a political question which I don't answer.
So to end our whole webinar, I would like to ask you, Harish, what are your 5 personal mantras for life? You know, this is for all our young generation. I mean, we have 2 big law colleges in Goa. Of course, there are many others also watching you eagerly. What are your 5 personal, how do you become a Harish Salve? What are your 5 personal mantras?
Well, first of all, why would anybody want to become a Harish Salve? You know, so I parked that issue. Let's assume somebody does want to embark on that misadventure. Well, if you want to be a lawyer, first of all, whatever work you do, when you choose your vocation, it should be something which you can pursue with a passion. The second is that never kill that little child in you. You must always have some mischief up your sleeve. And that is what gives you a lot of energy in life. The third is, and I've realized that whatever you pursue, always remember health is 9 points in life. I don't, as you know, I don't preach any virtues of abstinence, but good health is important. Fourth is one must always have an open mind, open to new ideas, and always challenge your beliefs. And always recognize that you may have, however strong a point of view you may have, there may be space for a divergent or a contrary point of view. If you keep that open and you keep challenging yourself, you grow your mind. And lastly, always be open to criticism. Criticize and be criticized. You must criticize yourself. As Mr. Palkhiwala told me, you must be your own most trenchant critic. When you come out of a courtroom, don't think whether you won or lost the case. Ask yourself, could anybody else have argued it better? If the answer is yes, you have a margin for improvement. If the answer is no, if you've lost the case, doesn't matter. Go home, have a drink, and everything will be fine. So always accept criticism and be your own most trenchant critic. These are the mantras, I think, of success.
That was brilliant, Harish. As always, it's always a scintillating evening with you. You are really a true gem, and your breadth and depth of knowledge and clarity today has, of course, always leaves me astounded. And of course, all the registrants, I'm sure, are inspired and educated. Thank you, Harish, for the gift of your time, especially on this weekend.
My pleasure, my pleasure.
And for leaving us with much to think about. Thank you again for the honor and privilege, and have a great weekend and a great evening. Thank you once again.
Thank you.
God bless.